already told you, this is one such mechanism where the parties can have settle their dispute out of court. Mediation, already told you that the mediator will be there. The mediator will try to convince the parties to the dispute and will also bring the parties to the memorandum of understanding, and we'll see that the parties voluntarily come forward and sign the memorandum of understanding. So to explain again, I can only say that when all the process is over, let us assume that in one particular case, the parties have come together and they have settled, and they have also formulated certain terms and conditions for settling their dispute. Once they have come to that level, then that should be reduced into writing. That art of agreement, meant it will be reduced into writing in the form of an agreement. So because once the agreement is, memorandum of understanding is accepted by both the parties. So once it is accepted by the court, so it will become enforceable. So it is binding on the parties that they should discharge their rights and duties which they had agreed to voluntarily before signing the memorandum of understanding. Therefore, this is in the process of reducing that memorandum of understanding into writing. The following dimensions are there in the mediation agreements. Just as you have studied that in the convincing, pleading or the drafting of pleading and convincing, there is a chapter convincing. There are many deeds, how to write a deed. Almost the same manner, the memorandum of understandings are also written. Same principles almost, but to some extent here they are everything will be cleared, nothing more, and no such confusion shall be there in the memorandum of understanding or agreement. That is very important because therefore there the parties to note, because mediator is also there, will be monitoring the entire process till the memorandum of understanding comes into existence. Apart from that, the following point to be noted, that while writing the memorandum of understanding, what you call an agreement between the parties settling their dispute out of court through mediation process, first point will be there shall be an accurate identity of the parties. It is very, very difficult. Like in the court also, if the court decides a case, writes a judgment, decides a case by judgment and decree, the name of the parties, case number, their address, age, everything should be there. Clearly should be stated. Because when the question of enforcement arises, there shall not be any problem for the parties to enforce it. If there is any change, if there is a wrong writing the name wrongly, or whatever. So if there is a mistake in the name of the parties, if there is a mistake in identifying the parties, so ultimately that memorandum of understanding will have some defect. That defective understanding sometimes may pay the way for creating a further dispute among the parties. Therefore, the accurate identity of the party should be there. Name should be clearly written. Usually one should identify as to the name of the party to the dispute. Therefore, one should be very, very accurate. Because even in the deeds also, if there is a names, if there is a mistake in the name, so the question of identifying the rights will be will come. So that question will come. The parties will be in trouble to knowing their own rights and liabilities under the document. Therefore, under such document. Therefore, name accurate identification of the parties should be accurate. It's common, everybody knows it. Here is the system where if there is any confusion regarding the identities of the parties, the question of enforceability will be a big issue. Therefore, parties to the dispute should be kept in mind while concluding the mediation process by entering into a memorandum of understanding. The identification of the parties should be accurately done. Secondly, reflecting the framework of the agreement. If you see the agreement, it should reflect what were the issues, what were the problem issues, and what are the solutions, what were the suggestions sometimes, what were the modes used in arriving settlement should be done. The framework, we will see it, there shall not be any confusion. What was the issue, first question, it should be cleared, and what were the views of both the parties, it should be, in nutshell should be there, and solutions, suggestions, in nutshell, it should be there. Normally, because that is required. Otherwise, what was the issues is the ultimate factor to know what has been entered into, what terms and conditions were put together, or terms and conditions are accepted and made at a time of discussions, at a time of consultation, at a time of communication, the two during the mediation process. It should reflect the framework of the agreement. There should not be any ambiguity. Priority of interest. After identifying the topics, just now it is a continuation of the previous one. So what was the issue? What was the main issue? So what were the real issues, interest involved in the case? This should be stated step by step. So there are, suppose take one example, in the family matters. While entering a memorandum of understanding for resolution of the marriage, the question priority, because marriage issue will come. Resolution of marriage, okay, but the next question, the properties issue will come. Next, the welfare of the minor child will be there. Next, maintenance question will come. Step by step, everything should be there. Say, that is why I told you that memorandum of understanding signed by both the parties with the respective counsel, countersigned by the mediator, will be sent to the court, which has sent the matter for mediation. That court, formal inquiry will be made by the court about the contents of that particular understanding. Court can have its own queries, can inquire, can have a one-to-one inquiry, consultation with the parties who have signed it. If suppose the interest, how the interests are aimed to be settled should be clearly stated. So just now I stated the family matters. In one case actually, which I have come across, what happened, both husband and wife who are agreed for separation. They want the divorce. Through mediation, it was over. At the time of inquiry by the magistrate, the concerned judge, the matter was placed before with mediation report was placed before the judge. Judge found a child a child was there. Normally, judge inquired about both parties. Firstly, judge inquired about that husband. So, have you agreed, have you voluntarily entered into this understanding? He says, yes. So also the wife. All right. Immediately, judge saw the child. The child was there. Then who will take care of the child? It is not stated in the that amount of understanding. Because child means, as you know, that welfare of the child is the, first of all, the court is the guardian of the minor child. The court will have to see the welfare. The most concern is there for the court, for the minor child. If there is any provision in the memorandum of understanding about the child, with whom the child will be, nothing was there. After knowing the intention of both the parties, because both wanted to remarry. Remarry means she may have her own child, he may have his own choice. They will be getting married once again with a different person. But about the child, who will look after the child? The court is concerned with the welfare of the child. In such situation, the court did not accept that memorandum of understanding. Court cautioned both the parties, unless you make a provision for the welfare of the child in the memorandum of understanding, the court warned that it will not accept. Unless such provision is made, it is not acceptable. Therefore, priority of interest, everything, though there are certain issues, though they may not be the major issues in settling dispute, but in the matters of like nature, that too pertaining to the minor children, the party should be very clear. So clear provision should be made in the memorandum of understanding. Therefore, the prior interest after aid for the topics, it should be clearly stated in the memorandum of understanding. Also, because in a situation like this, just now I told you that whom to protect the child, because welfare of the child is there, that question is involved. Court is the guardian in such a situation. If they are not looking after, then how court allows the party to separate when their own child is there, when there is no provision for the minor child? That is why there should be noted that priority of interest one by one should be stated there. Interim agreement, fourth one. So you know that while there are many memorandum of understanding, that suppose for example in a situation like this, party has agreed to pay the balance amount within 2 years. Say for example 20 lakh is the amount of that particular dispute, subject matter of that particular dispute. So within 2 years will be a long period. Therefore, interim arrangement can be made in the same memorandum of understanding that there can be 20 lakh. Out of that, at least 2 lakh should be paid within 3 months. Another 2 lakh shall be paid within 3 months thereafter. Like that, such interim arrangement could be made in the same main agreement. Some interim agreements can also be there. So such a type of terms and conditions can be there. Can be there because ultimately what we say that our aim is to see that the parties should get the matter settled out of court. Revisions, say temporarily writing memorandum of understanding, because of final draft maybe will be there. For final draft, before that, many temporarily writing in a memorandum, writing memorandum of understanding, roughly first initially, and after making several corrections, final draft can be put forward for the purpose of signing of the parties. So at any time before the final draft is ready, it can be revised because revised. Therefore, that should be kept in mind. It is also one such aspect where it will minimize the mistakes, minimize the problems to be happened once the final draft is ready. Draft of memorandum of understanding is ready. Ceremonial signing, reading the agreement open after the final draft of the memorandum of understanding is ready. The contents of the memorandum of understanding should be read over to the parties in presence of the parties, if possible in presence of their their lawyers, because in presence of their lawyers, in presence of the parties, the content should be read over to them, so that both the party can have any doubt to be cleared, because whether whatever they agreed, whatever they had, whether that has been reduced into writing or not. Sometimes by mistake certain conditions might have been deleted, sometimes intentionally. There are instances where the conditions, terms are deleted also while drafting the final memorandum of understanding. Sometimes inadvertently, sometimes writing, putting the words will have a different meaning. Clarity should be there. Therefore, to have a clarity on the final outcome of the memorandum of understanding, it is better that it should be read in openly, the agreement before the parties, to avoid any such future problem that may occur because of any mistakes. Therefore, after clearing all the mistakes and doubts only, the last steps will be ceremonial signing. All the parties, they must read each and everything. Only after concluding, only after confirming whatever they had in their mind is written there, then only they can put their signature with their respective counsel also. Therefore, there is a scope. Ultimate aim is that once the matter is amicably settled, means it should be settled once for all, forever, because they should not come again for any such meeting. There are many cases still there. At the time of compromise, writing a compromise petition, there are many situations where the survey numbers are wrongly written. Extent of the land, some are also wrongly written. It should be looked into very clearly. Therefore, clear clear understanding, clearly knowing each and every terms and condition is important aspect before signing. Once it is signed by the parties, once it is accepted by the court, it cannot be revisable unless or without adopting any other due process of law, because and another corrigendum can be done. But again, party should come again, and again correction could be carried. It again creates another problem for them. Once for all, they have spent so much of money, so much of time, extracted again for a correction. Parties to come means it means it will be of no value. Therefore, all the points should be kept in mind. Hurriedly should not be done. So, in a phased manner, all the proceedings will be done in the mediation process. So, apprehension should not be there in the mind of the parties, because the party should have say a sense of feeling that they have got some justice, because absolutely, as you know, that it is a win-win situation. So therefore, no question of success and failure in the system of resolution or the system of deciding the case. This is altogether different from the one which you see in the court. Here, the parties, already I have told you elaborately that they have their own method of settling or resolving the crisis between the parties in respect of any matter, any dispute. Therefore, please note that these points to be taken note of. Nextly, as you know that mediation, there are two types, you know, that already I told you initially, facilitator and evaluator. Facilitator means mediator will facilitate the party to have such number of communications, discussions, etc., etc. Because ultimate aim is that solution to the dispute is the ultimate aim. Therefore, it is facilitative mediation. While they will facilitate. So, if there is any confusion, again mediator, whatever means, try to convince, facilitate, to have a amicable conclusion in the matter, evaluate in substance of the matter, everything, whether if such a decision is taken this way, whether it will suit or not, it will help or not, like that it will be seen, it will be evaluated, the whole process in respect of the dispute which is going to be settled out of court. This is because I have explained it elaborately, but now you can only say that this process itself is a voluntary process. So apprehension, they need not apprehend. So there will be sense of feeling. That is insecurity will not be there. Some sort of happiness will be there, because settling in a win-win situation, both will be, I think, will be happy. So there's nothing to gain or loss after the mediation process is completed, because it is because of just the reason, because of that reason we are. This is the best method nowadays, so that what you have heard from Article 21, that speedy disposal, speedy trial, they are also the fundamental rights. In a situation like this, it is also possible, it could be possible, because speedy disposal, getting the solution at the earliest could be possible by resorting to this mediation process. So now directly I am coming, because having studied about the mediation system. Now there are different models of mediation. You have already heard, because mediator normally employ those models in deciding case, depending upon the different case, depending upon the party, depending upon the issues involved in the dispute. Normally, mediator employ different models of mediation. See, therapeutic mediation is one such. So means they see, for example, she or he will give a touch to their quasi-religious compulsion, because they say, suppose in family matters, or they may say, they may also convince the party in such a way that no, it should not happen. Our religion don't permit, like that, some compulsion, some ethics in their respective religion can also be, which is one method it is being used. So they themselves, because in those days getting the family matters to the court was not there. Rarest of the rare cases used to come in those days. Nowadays, every case will come every year. So number of family disputes rise every year. Year by year it go on raising nowadays. In those days, therefore, giving it is a hard touch issues. No. The family matters, first of all, should not come out from the family, because religion don't permit. Once a marriage has taken place, it is for the couple to live together and think their differences within the family and live happily. Like that compulsion is there. So it is also one method, even without having a recourse to the mediator, they can also solve it. Facilitative, evaluative, just now I told you. So facilitating the parties to take the assistance, communications, etc. for deciding the case, evaluating the substance of the case, which is right, which is wrong, which has to be taken as a means to settlement, and which solution will be the final settlement to the dispute involved. So that is called evaluating. Direct to mediation means, so as you know that clear-cut instructions will be in writing. So one convincing nature. Another one is conduct. The terms and conditions will be there. Suppose a dispute between the consumer and the salesman. So the settlement here that while purchasing any materials, bill will be issued. Behind the bill, conditions are there. Amount will be there will be no exchange. Exchange offer is not there, like that. It is strict to formula. It is already scripted. According to that, it will go on. The scope is very limited here for mediation. Classic page to page. It is setting the problem, or settling the problem. It is a pure process of mediation. Say, knowledge sometimes may not help, but just a process to be followed. So, in a given situation, parties, while following the process itself, they will find a solution. So, some knowledge, experience sometimes may not count. Pure process, that they will think. They will come together and exchange of views and coming to a particular solution. Commonly it will go on. They need not, even the experience sometimes, knowledge sometimes will not help here. Therefore, normally in this mediation process, at some stage, at every stage, any one type of model is almost employed by a mediator in the mediation process. See, this is regarding more, I think you can also go through the reading materials available in the library. So I can also furnish this through PDF. The students may go through each and everything, can write examination. I'm only giving some hints about these things. See, there is a model. Nextly, come to another issue, that is a model code of conduct for mediator. As you are all aware, model code, every mediator is called as a convener because it brings together both the parties. Rest will go on, as you know that is. So far we have studied. Like he will be like a convener. Educator will educate the parties. Facilitator, again, facilitate to mediation. So communication process facilitator. So pave the way or facilitate the parties to communicate each other, whichever method, so in whatever way. So ultimate aim of that mediator will be to find a solution that should be the outcome of the mediation process. Therefore, translator, sometime if there is any problem in understanding the words, the meanings, etc., it can be translated. Words can be translated. Meaning can be, because sometimes language problem may also be the reasons. So, model code, these are the code. She or he may have to translate so that the parties can understand, to have a better understanding between the parties, better understanding, so as to arrive a memorandum of understanding between the parties. Questionnaire and clarifier. So can put a question, can clarify also. Code, natural. He can put some question, can clarify the questions asked by the parties. That is another code of conduct of every counselor. Sometime act as a counselor. I mean, act as a counsel also. Counsel, because explaining the consequences of such a dispute which is on hand, making known about the events that may happen, that may not happen, but for the benefit of the parties. Act as a counselor. So a catalyst, a system is there, which catalyst means one by one step it will be there. If that system is used, it should be the result like that. Mediator can also use that catalyst to benefit the party so that can have a better understanding. And the mediator will be a responsible record holder. I mean, putting the parties on one track. The mediator will see that the parties go out of the track. So everything will be on track. So work towards finding a solution to the dispute in question. Dispute which is on hand. Therefore, these are all called as a code of conduct for mediators. I think these are all the chapters. I mean, small chapters. These are all common in the mediation process. Ultimate aim, I told you, that at any cost, the solution should be the main result. Solution should be there, amicable solution should be there to the parties. In the final chapter, in this fourth unit, lastly, you know, what are the advantages of mediation? I discussed it in the first chapter itself. Nothing but repetition. Advantages means it is free. This process is freely available. So you will not pay fees for that. Therefore, the mediator will be there. Matter will be referred to the mediation. Mediator will assist you. Almost like that is by adopting any of the modes of mediation. Therefore, freely available. No question of spending the fees for approaching the mediation. That is one advantage. Fair and neutral, I told you, fair and neutral. So fairly it is done. So impartiality will be there. No question of any kind of apprehension in the mind of party. Need not apprehend about impartiality or unfair activities in the process of settling dispute through mediation process. High rate of compliance. Once the memorandum of understanding has been reduced into writing voluntarily, the question of complying, because once the agreement is over, once the memorandum of understanding is accepted, once it is accepted by the court, the case will be disposed of in terms of memorandum of understanding. So once the case is over, by coming to the memorandum of understanding, parties, because it is a voluntary process, when they voluntarily they have entered into, then compliance, that terms and conditions will be complied, will be respected, obeyed. Therefore, high rate of compliance will be there. Why I am saying, if the court if you allow the court to decide the case on merit, if you win the case from the court, so you have to institute execution proceedings for enforcement of judgment and decree. That has its own procedure under CPC. It will take its own procedure. Again, 1-2 years will be there. So you may have to spend another 2 years for the purpose of getting the fruit of the judgment and decree of the court. Suppose the party may therefore the compliance by way of instituting execution proceeding will be there. Another again risky will be there. Here, when the party have voluntarily entered into a memorandum of understanding, so voluntarily they will comply their own terms and they will discharge their application under the because as you know in the if there is a valid contract means section 2H says it is entered into between the parties, the agreement which is enforceable at law. So party can perform their obligation. Here they will also perform their obligation because voluntarily they have entered into. Therefore, while discharging the obligation, the rate of discharging the obligation will be more in the process of mediation. Comprehensive and customized agreement. So it will cover all the aspects. No doubt will be there. No confusion will be created. Is it not? Everything will be clearly stated. After the conclusion of the proceedings, there will be no room for further aggravating the situation, further creating a further dispute, further approaching the court. That will not be there. All the aspects will be looked into in this process. Confidentiality, I told you that once the matter is solved through mediation process, whatever the discussion made during the mediation process will not be disclosed. Everything will be kept in secret because there will be no scope for raising any new issues. Everything will be confidentially done. Everything will not be disclosed. Whatever happened during the mediation process. And I already told you in the previous chapter that nothing will be brought before the court. Even assuming that if you fail in the mediation process, the matter will go before the court for continuing the proceedings in accordance with law from the stage where it was stopped. So during the process of continuing the proceedings by the court, whatever happened during the mediation proceedings, whatever the discussion, whatever the documents showed before the mediator, all those things will be kept under secret. Nothing will be reduced into writing. The proceedings will not be recorded. It is highly confidential. It will not be disclosed. Therefore, you need not bother. Suppose if you have said something before the mediation proceedings, sometimes you may feel that other party may bring to the court whatever the party has said during the mediation proceedings. That apprehension should not be there, is not there, will not be there. Because confidentiality is there, it will be kept under secret. Next, avoids litigation. Once matter is settled, further litigation will not be there. No question of appeal. If the matter is settled by the court, appeal, counter appeal, next higher court, up to Supreme Court matter will go. Here the question of further litigation will not be there. Matter comes to an end if you complete the mediation process with the memorandum of understanding. No question of further litigation. Fosters cooperation after litigation. Both the parties can live together as if nothing has taken place. Because there is a win-win situation. Everyone wins. Well, everyone wins. Win-win situation. No question of failure, no question of success, etc. All the parties are winner. Therefore, improves the communication also. The litigants, they will forget what happened previously, so they will enter into a new life, improve their communication, cooperation will be there. If the court decides the matter further aggravated, the party winning the case or losing the case, there will be different problems. Appeal, counter appeal will go. So further aggravate the situation between the parties there. But here it will not be there. Because win-win situation, both have won the case. Therefore, no question of such a problem in the future. Tailor-made solution accurately once the problem is solved. No question of getting back to the same problem. That question will not be there. Personal empowerment, because parties are having the command or control over the issue. Therefore, they themselves have decided personal empowerment. They did not allow the court to interfere in your case in a cool manner, amicably, before the mediator. You are settling the matter. So in the open court, open court, producing many documents, making a statement, entering into the witness box, so everything will be there. But here, personally, you yourself have settled the matter. That power is there in the mediation process. So you are the masters of settling your own case. Therefore, personal empowerment will be there. Here, preservation of ongoing relationship. I told you, once the matter is settled, the mediation, the same relationship between the parties will continue. Your relationship will continue to be preserved. So forever you can go lead happy life. Therefore, I told another advantage is there. It is not court-posted, but so no question further appeal. But parties are also encouraged by another way. That is, if you settle the matter through mediation process, there is chances of getting the refund of a court fee also. Another advantage is there. So you know that you don't know, suppose in respect of property, immovable property in the Bangalore, perhaps you may have paid huge court fee, 1 crore, 2 crores. If you settle the matter through through this mediation process, court sometimes may refund the 50% of the court fee or 90% of the court fee. It depends upon the case to case. That is also another advantage. So finally, I conclude what I mean to say, that it is a process, voluntary process. Party have their own calculation, their own empowerment, they have a command over the issue. They can amicably settle and amicably they can settle. They can live as if nothing has taken place after settling the dispute. Therefore, it is almost like a win-win situation. All right. Thank you.